Hello, everyone. Welcome. This is our third and final installment of the Spyware webinar series this semester. Thank you for joining us. As we've said before, this webinar series is meant to give a platform to stakeholders in the commercial spyware governance community to give us their opinions on how to best move the international governance debate forward. So we're delighted to welcome Professor Asaf Lubin today, who's very kindly agreed to spend the morning with us, who's going to give us a very good case for why we need an international agreement to effectively and comprehensively govern this space. Now, Dr. Asaf Lubin is an associate professor at Indiana University, Maurer School of Law, and an affiliated faculty at the Hamilton Luger School of Global and International Studies. He is additionally a faculty associate at the Berkman Klein Center for Internet and Society at Harvard University and an affiliated fellow at Yale Law School's Information Society Project. He is also the author of The International Law of Intelligence, The World of Spycraft, and the Law of Nations, which is forthcoming with Oxford University Press and will be published next year. So we have a very distinguished speaker today who is going to present about Beyond the Ban, building a human rights compliant spyware market. And in this talk, Dr. Lubin will expose how the multi-billion-dollar spyware industry, fueled by zero-day exploits and shielded by corporate obfuscation, has outmaneuvered every law, sanction, and enforcement measure thrown at it. In his talk, he'll challenge the seductive simplicity of global moratoriums on the industry and show how they offer little more than the illusion of safety. Instead, the talk lays out a bold blueprint for a multilateral regime that can reclaim control over current and future surveillance technologies before they irreversibly erode human rights and democratic governance. And with that, the floor is yours, and we're very excited to hear what you have to share with us. Thank you, Asaf.
Awesome. Well, thank you so much for inviting me. And this is such a great opportunity for me to share some of my work. I will mention that the presentation is building on a paper that I published. It was published this year, but it's technically written as 2024. But it's in the Ohio State Law Journal titled Selling Surveillance. And so if you want to get even more deeper into the arguments I make in this presentation, you can find a full article online. All right, so I thought I'll start by just positioning myself as an academic. So my background is that I worked as an intelligence analyst for about 5 years in the Israeli intelligence community. And then fast forward some 10 years later, I ended up at Privacy International, which is an NGO that sues governments for their spying. So I like to say that in a 10-year time span, I went from working for a spy agency to suing the spooks. But I'll tell you that during that time, in both of those worlds that I obfuscated, I found myself routinely being the person pushing back within a conversation, be it within the intelligence environments that I once occupied, and even at Privacy International. Not once I remember them turning to me and asking me if I'm the mole in the room, the guy formerly working for government intelligence agencies. And the reason for that had to be with the fact that every time we would write a report or submit something to the court, I would have suggested various kinds of adjustments to our arguments. And often those positions were not adopted ultimately by the organization, in part because, as they said to me, and I think justly, Privacy International as an NGO is here to present the purest account of privacy. If we won't do it, they said, who would do it? And I think the national security hawks often speak in much the same language, saying, if we don't get to represent the purest account of national security, who gets to do it? And so often the conversation operates at this chasm between national security hawks and privacy or digital rights protecting doves. And the reality is that there's very few people who operate in the center. And that's the kind of scholarship that I produce that I dare call pragmatic, and people take various views on that word. But that's also the proposal that I will try to bring forward today. And so to situate ourselves, we obviously are talking about the kind of spyware, because spyware is an undefined term. And so for our purposes, just to use an example, we are talking about the kind of spyware that was the cause of much controversy in international media over the course of the last several years in the wake of the Pegasus project and the revelations of the way this one tool, one example tool, and mind you, there are many more spyware companies like NSO, but one tool, which is Pegasus, and how it was used against human rights defenders and journalists and political dissidents to engage in gross human rights abuses. And what I have found when I had come to research this topic is that governments, in trying to respond to the threat of spyware, and particularly its abuse against these kinds of human rights defenders, have treated spyware like any other technology company. They said, listen, if spyware is a technology that can be used for both good and bad, it's a dual use technology, then why shouldn't we regulate it like we regulate other dual use technologies, like encryption technologies or computer chips or 5G networks? That is, we'll just apply export controls to regulate it. Or they might say, spyware companies work the same way as some of our tech giants in managing data. And so maybe we should regulate them the same way we regulated those tech giants by imposing on them certain human rights obligations and then enforcing those through self-governance. Or maybe we'll say spyware companies operate in some of the same way that those who violate privacy and data protection regimes do, say Huawei. And so maybe we can enforce against them through ad hoc civil and criminal litigation or through sanctions or through some kinds of enforcement solutions. And if all of that fails, maybe the solution is to just ban the technology. I mean, think about the way the US attempted to treat TikTok as a technology threat. Maybe the solution is just ban it from being operational within our territory. And so in the paper, I suggest that this is a kind of toolbox that governments often deploy in the face of threatening technologies. And this toolbox, I argue, as was mentioned in the introduction, is ineffective in addressing the threat that commercial spyware poses. And so I'll briefly walk through each of these solutions and demonstrate both the benefits and the pitfalls. So when we think about export controls, a core regime that we might think about is the Wassenaar Arrangement on export controls for conventional dual-use goods and technologies. And indeed, what it offers us is an international arrangement that provides a forum for negotiation and that promotes some form of collective implementation among the members of Wassenaar. But the reason that Wassenaar, which had attempted to regulate the use of particular technology, intrusive technologies, did not work in actually preventing the spyware spread that we see and use that we see today, is that the first Wassenaar is a non-binding mechanism that lacks real enforcement mechanisms, that a set of key players are not parties to it, including those from which spyware companies operate. And that includes Israel, that formally does say that it is compliant with Wassenaar despite not being a party. But others might include China and Cyprus, which is where a lot of spyware companies moved to in the wake of particular restrictions in Israel. As well as the fact that Wassenaar itself does not prohibit the purchase of a surveillance technology from a non-participating state. And so you can continue to buy from a China or from an Israel or from a UAE, despite them not being part to Wassenaar, even if you yourself are a member of the Wassenaar regime. So all in all, what Wassenaar produced is a weakest link sort of problem, wherein corporations will exploit loopholes within the system, operate from countries where membership is not a requirement. And what that led to is a weakening of it as an enforcement mechanism. So another solution, as I mentioned, might be to turn to human rights law. Part of the problem in applying human rights law in this space is the complexity of the actors involved in the spyware supply chain environment. We have the spying state, that is the entity that's buying the technology, the company itself, which is a non-state actor, and then the licensing state, the country from which the spyware company operates. And each of them operates with their own incentive structures and motivations, and the ability to employ human rights law to regulate each of these three actors is extremely limited. So if we might think about the spine state, I'll just give you concrete examples. I won't go through the entire list. But for the spying state, many of these spying states think about Saudi Arabia using NSO Group's Pegasus to go after Khashoggi in the lead up to his butchering in the embassy in Turkey. Saudi Arabia might not be a party to the relevant treaties in question. Moreover, it might not agree on the way those human rights frameworks apply to the conduct of national security activities, which might be a limitation on the applications of particular human rights regimes. It might also derogate from certain human rights obligations in the perceived claim of a public emergency. And so human rights law is not effective in restricting the spying state. There's also a lot of questions of how human rights law, even if privacy is a human rights applicable to the country in question, how might it constrain the specific use of spyware in practice? How does it apply to constrain the kind of functions that spyware provides? As for the companies are not themselves bound by human rights treaties as such, but we need other instruments, typically domestic instruments, that could impose human rights obligations on those companies. That is precisely what the UN guiding principles, the UNGPs, try to do. They try to impose obligations on states to impose domestic law obligations on those businesses that would be compliant with human rights law. The problem is that the states who are employing these domestic laws are not uniform in the way they apply them, and certainly not uniform in the way they enforce them against these companies. And so, if enforcement depends heavily on domestic framework, there is a question of whether or not countries who are selling these technologies and are therefore benefiting from a vibrant spyware industry within their territory, how incentivized they are to actually enforce against them. There is also, of course, no real incentive for the companies to self-regulate because there is no buyer market that is indicating that they will only buy if the companies are demonstrating some kind of human rights compliant. And so it becomes a race to the bottom. I'd already talked a little bit about the licensing states. I'll just say that in the context of, say, the Israel NSO Group example, one of the things we saw is that Israel benefited from what you might call surveillance or spyware diplomacy. The idea that these companies are a leverage against which the promise of selling these tools, it could get certain diplomatic advantages from other countries. New York Times reported that the Abraham Accords were achieved in part by promises from the Israeli government that it will assist in the selling of particular kinds of surveillance tools to the participating states in the Accords. And so you have here an industry that is also supporting diplomatic and political ambitions, further disincentivizing the licensing states from actually regulating. It's also important to note that the licensing states are hard to deem accountable for the selling of a technology to a third country who then uses it to commit a human rights abuse. For that to be applied, we'll need to develop due diligence obligations, complicity rules that will be strong enough to reach all the way back to the licensing state, which operates often with some kind of blissful blindness towards what the activities are that the spying states are engaged in. And so, all in all, human rights law, in my view, seems to offer a limited tool in the toolbox for the regulation of these companies. Next up is ad hoc civil and criminal litigation, sanctions, and other enforcement mechanisms against the companies. And here too, there can be some benefits. After all, we might hurt the company's liquidity and bottom line. We might deny the companies access to certain necessary infrastructure. Think about the way NSO Group was denied access to certain cloud services that it needed in the wake of enforcement action by the United States. We can target particular employees or CEOs through visa bans. And we can produce reputational effects so that no one would want to work with a company that is deemed a bad actor. The biggest pitfall here, in my view, is that it's a whack-a-mole solution. It's an ad hoc response to what is a systemic market-wide problem. And so for every company you're successfully hitting, there will be several other companies who might mushroom through mergers and acquisitions because these companies are very nimble in the way that they evade and move through sanctions and sanctions regimes. Indeed, NSO Group, which is by far the company that has suffered the most kinds of both civil, criminal sanction action against it, is still very much alive years after these sanctions and has recently been purchased by an American company. And so the idea that we can eliminate this threat through ad hoc responses, in my view, is wishful thinking. And it risks prioritizing some of the companies that are most in the news, those that will get most targeted by these very expensive, very time consuming litigatory action, while leaving a bunch of other companies who might skate under the radar unharmed and unaffected by these kinds of enforcement actions. Um, so against this backdrop, what we've seen is a call for just a moratorium, a ban on the industry. There have been a number of actors, both from the European Parliament and from certain special procedures at the Human Rights Council, including former Special Rapporteur David Kay, who have come out and said, we need a ban on this industry. The problem with that call, why I think that call does not offer us anything more than the promise of security, but a reality of insecurity, is that first, we are struggling to define the very thing that we want to ban. Even across those individuals and entities that have proposed a ban, there have been a lot of disagreement on what it is that we should ban and for how long should it be banned. Is it forever or until such time as we can develop a human rights framework for regulating it? Um, but there's, I think, a more profound problem in this context. And that is what spyware does in the interim if in a universe in which surveillance is a necessity for law enforcement activities. So to explain this bigger point for me, let me talk a little bit about the idea of going dark. So this is not a new concept by no stretch. I think it became popularized through a lecture by James Comey, former FBI director, in the 2010s. But the idea is that as we move towards end-to-end encrypted communications, there is less and less ability by law enforcement when necessary to engage in the investigation of serious crime and national security investigations to trust that they will have the ability to access the evidence they need. So going dark refers to the operation in the dark by law enforcement agencies and national security agencies in the face of legitimate investigations. If we don't allow them the capacity to hack lawfully under certain human rights standards, we are leaving them demanding backdoors. And that is precisely what happened in the wake of the going dark debate in the 2010s in a famous case called Apple v. FBI. This is a case that involved the shooters, husband and wife shooters in California in a terrorist attack who used Apple devices to communicate between them. And in the investigation of that terrorist incident, the FBI wanted to access the devices and struggled to do so. And so they sought a court ordered under something called the All Writs Act that could compel Apple to break its own security. And that led to a big litigation that was never resolved because before a judgment could be reached, the FBI sought the help of a spyware company from Israel called Celebrite. And that company broke the phone and thereby allowed the FBI to access the communication it needed for its investigation and to drop its very controversial demand that Apple will otherwise break its own device. But before you think this is a one off, all throughout this year, we have seen yet a similar saga play out in the United Kingdom, where the Home Office demanded, under the Investigatory Powers Act legislation in the United Kingdom, that Apple will essentially break the security of its own devices and provide access to iPhone users' data. Um, Under something that the IPA, the Investigatory Powers Act, authorizes the Home Office to do, which is to request the assistance of technical assistance of any company, technology company, it deems fit. And that's what it sought to do. There was some back and forth with the United States. And ultimately, the UK backed down of its orders from Apple at US's demands. This happened just in August. But in October, it was reported that the UK made new attempts to access Apple Cloud data, this time issuing an order through the Investigatory Powers Tribunal demanding that Apple will access only data of UK users. So the only change that was made is to focus it on UK clients. But the idea is still the same. You need to break your own device. And just so we understand the concept of backdoors, anytime you create a backdoor for a good actor, that backdoor will be used by a bad actor too. You can't have it both ways. That's the risk of killing the spyware industry. The spyware industry is an alternative to the backdoors debate. Instead of backdoors, instead of compelling the assistance of these companies who are called to break into their own devices, we have companies that specialize in vulnerability identification and then sell these vulnerabilities to governments to use in their legitimate investigations. In my view, it is a pressure valve. It is not by no means a panacea to the problem. But in a world in which the alternative is ending end-to-end encryption by the creation of backdoors, I take the world in which we have limited regulated use of spyware. That is just, in my view, the only other alternative in what is otherwise a bad game to play to begin with. Um, and just so you understand, that is also the position of the European Court of Human Rights. That court issued a decision in Podkasov v. Russia in 2023, where it made explicit in a unanimous bench that policies weakening encryption and security of communications, including through mandatory backdoors and compelled forms of assistance, are inherently disproportionate and violate the right to privacy. It sent a strong message about the vital importance of encryption and in an ever digitizing information society. But the European Court has never done the same with regards to surveillance. So the court authorizes the government to surveil, including by way of lawful hacking, but it prohibits as disproportionate any demands for the breaking of encryption by governments against technology companies. I think that that balance that I'm proposing is the balance that the European Court of Human Rights has struck similarly. So I guess we're left with the very question with which the presentation is dealing with. How might we reorient the marketplace? How can we reimagine a legitimate market for spyware, one in which we leave the technology available, but only under very scrutinized, regulated framework? And so to begin with, I will suggest to you that there are others who have made this proposal before me. Former Special Rapporteur on Countering Terrorism, Olin, has already said in a pretty detailed and terrific report that I would put to you to read in April 2023, that a regulatory framework does not have to take one hard and fast approach. And that they offered a couple of ways to take forward a regulatory proposal of this kind. Here's what they included in their proposal in their report that the Special Rapporteur suggested. First, they will be international in nature, either by way of a treaty or by way of a relatively consistent adoption by a large number of states. Second, they would depend on state obligations as a mean of regulating corporate behavior. Third, they'd be limited to the spyware field. Fourth, they will entail compulsory and concrete action on the part of the states. Five, that it will impose actual liabilities upon private entities developing spyware to undertake due diligence, showing there is no real risk of spyware being used by clients to breach human rights. And finally, they provide direct form of accountability, vindictable in domestic court whenever the company fails to do so and the spyware has infected the target. I agree with all of these elements with the exception of one, and that is that it be limited to the spyware field. In my writing, I think it is a better approach to develop an international framework that applies equally to all surveillance tools. And in fact, that has been the Biden administration's position in the wake of the efforts of the United States through the Summit for Democracy to get a group of governments coming together to regulate the spyware markets. So, in their most detailed guiding principles, 45 countries agreed to regulate their surveillance technologies industries in a general set of through a general set of principles. And that guiding principles document defines surveillance technologies as a broad concept, not a narrow concept, which will surely include spyware companies, but will include many other surveillance companies that provides both products and services. Technologies used for surveillance can refer to products or services that can be used to detect, monitor, intercept, collect, exploit, preserve, process, analyze, invasively observe, and/or retain sensitive data, personally identifiable information, including biomarkers, communications concerning individuals or groups. That kind of a broad definition will capture a wide a swath of technologies. And the idea would simply be to create a multi-stakeholder framework whereby any technology company that fits somewhere in that definition will be invited to take part in the framework. And then countries operating within the framework will agree that they will only buy technologies from companies in the framework. So why restrict ourselves to just spyware? If governments are increasingly relying on surveillance technologies, mandate that they only buy surveillance technologies from certified companies, companies that are in the framework, across all surveillance domains. I think that that is a better approach. So under this logic, we will be reliant on the procurement power of the governments as a leverage, a strong leverage to incentivize companies to bind themselves. So we're not trusting on self-regulation by the companies. Rather, the companies will take part in a framework institutionalized in such a way where both governments and civil society actors have a say in the review of companies' compliance with the standards. And those corporate obligations might include a wide range of things, from the way the technologies are developed, how they're marketed and sold, how they manage their clients and when do they terminate client relationships, how they establish mechanisms for whistleblower protections, for internal grievances in the case of abuse, and from oversight from both civil society and governments to ensure compliance. Since we're also dealing with the unique case of vulnerabilities hoarding, of the hoarding of zero-day vulnerabilities, which are the most notoriously risky kinds of vulnerabilities in the marketplace, we might want to impose on the companies also particular obligations on when they might need to share these vulnerabilities that they've collected with the government. So to avoid a privatized marketplace for extremely dangerous vulnerabilities, the kind that could completely severely impact our digitized marketplace. At the same time, the same framework will impose obligations on both buying states and states who are licensing these technologies. And most of that framework is actually a framework that human rights law lawyers will be familiar with, since it was adopted to regulate surveillance and all surveillance technologies. A set of principles dealing with a legislation in place that sets requirements for necessity and proportionality prior to the employment of the technologies, adequate safeguards during their use, and ex post review after they've been employed. They should also include obligations on how you provide access to remedy to victims of abuses, standardizations on when and how you procure this, what mechanisms of human rights impact assessment are you engaged in the procurement stage, what regulations on rules of engagement with the technology will involve during its use, standardizing the licensing and through a multilateral framework, enforcing it across the entire member state ecosystem, and demanding that all governments have a vulnerabilities equities process, a process by which the government assesses vulnerabilities that are now shared by the companies with it under the same regime, to ensure when is it necessary to not hoard the vulnerability, but rather release it back to the marketplace to be patched because it uh, presents such a severe risk to the marketplace. In my last few minutes, I just want to highlight that this entire model is not new. It already exists in a different context, and that is in the International Code of Conduct Association. This association regulates the involvement of private military security companies in warfare. There too, go back 15, 20 years ago, we have seen a significant risk of a corporate actor that is involving itself in security affairs in ways that pose risks to human rights law. And there too, the international community came together to create a multi-stakeholder framework, which job it is to regulate these businesses and to incentivize only working with companies that are deemed certified. That's what ICOCA did. And so I proposed in my paper that we build on the lessons from ICOCA, both where it went well and where it failed us in certain respects, to improve and generate a model for the regulation of surveillance industries. After I wrote that paper, I was approached by colleagues working at the International Code of Conduct Association. What I learned is that actually any kind of multi-stakeholder framework to regulate surveillance will actually benefit ICOCA too. And that's a conversation I wasn't expecting. So here's why. Um, as it turns out, wars as we know them are becoming digital. And so the same kinds of private security and military companies are employing these sorts of technologies that we're talking about, spyware, surveillance, cyber tools, to conduct their security operations in the battlefield. And so as a result of that, a regulation that first was meant to regulate a Blackwater, a kind of company that mostly provided physical security services, the same framework now needs to address a new set of actors. Security services that provide infrastructural tools from encryption to cloud service providers, mobile and IoT developers who are assisting military operations in war, the use of artificial intelligence embedded technologies, which been developed and used by these PMSCs, by these private military security companies in battlefield situations, the use of data aggregators, data processors, and data brokers in war, and indeed the use of spyware in the context of wartime activities. And so what my colleagues at ICOCA were telling me is that they're facing questions about how their regime could better regulate spyware too, because they are faced with PMSCs who are employing spyware in armed conflict. Now, this is almost the new frontier of the way we conceptualize spyware regulation, because up until now, we used to talk about spyware governance solely in the context of peacetime activities, typically remote activities by one government against dissidents in a foreign nation or one government against dissidents in its own territory, but all in a peacetime environment. Now we're starting to see the use of surveillance tools across all their applications in wartime environments too, and we might ask ourselves how we could regulate these industries also to support these efforts. So I want to stop here. I hope I've been provocative enough to generate a bunch of questions and discussion, and we can take it from there.
Thank you, Asaf. Thank you, Asaf. That was very impressive. And I know that I have a whole bunch of questions. So I'll just say to the attendees, if you have any questions, please throw them in the chat for us to discuss. In the meantime, I'll just get started with a whole bunch of things that I picked up in your presentation. So thanks again for giving us really tour de force of all the different measures that, have so far failed to comprehensively address the spyware market. So I'll start with the first thought that I have, which is I really appreciated you tying the spyware debate into the going dark debate, because I feel like for, the majority of the past few years, the spyware debate has really been held in isolation. And I wholeheartedly agree with you that, it is, I really like how you put it as a pressure valve, that it has really evolved as an answer or as like, some things that governments have tried to do to, you know, to address this Gordian knot of going dark or, of encryption of, how to address the that dilemma that they have that, they want to get to the information and it is increasingly more difficult to get to it. So I really appreciated the framing and, adding that context of the going dark debate to it. So what I'm curious about, I feel like the last time we had a more or less more comprehensive debate about surveillance and how we use it was in the wake of the Snowden revelations in 2013. Now, of course, this is a different debate because that was about mass surveillance. And at least for now, we still characterize the use of spyware or cyber intrusion capabilities as targeted surveillance. I know there's a whole other question or bucket of questions there, but let's try to stick to this dichotomy now. So the last time we've seen a debate about regulation in the context of surveillance was about mass surveillance practices revealed in the wake of Snowden in 2013. Now, in that debate, we heard a lot about concepts like legitimacy and proportionality, whereas in the spyware debate now, we hear about responsible use, and irresponsible misuse. Not so much, in my view, about proportionality and how that applies. We have a little bit of legitimacy in there and legality. So I was curious on about your take on, how do these two debates compare? Can we compare them? Can we look at the mass surveillance debate and look at the lessons learned? Is there something that we can take for the regulation of spyware? Should they be treated completely separately? Or, why do you think that has been the case?
That is such a
So, yeah,
yeah, no,
curious about your take on that.
such a great question. And so let's just start. So I mentioned I work at Privacy International. I was working at Privacy International in the wake of the Snowden revelations, where Privacy International was bringing all these cases, including being party of the Big Brother Watch the UK case, which ultimately was one of the bigger decisions from the European Court of Human Rights in the regulation, at least at the European level, of human rights against mass surveillance tools. And for an NGO like Privacy International, by the way, that fight is not over. It's still ongoing. That we seem to have settled on a set of rules in human rights law that legitimate particular categories of mass surveillance, and that have set a framework for how you engage in lawful mass surveillance. And for some human rights law, that framework isn't good enough. That framework has resulted in more permissive forms of surveillance that should be restricted. And so what I'm getting at is that we have a debate around mass surveillance that for some is not resolved, is not kind of settled yet. And so while we have that ongoing, we have this separate debate now on the use of lawful hacking. And lawful hacking too can have mass surveillance uses, right? Some of the Snowden revelations were about the use of particular hacking in order to achieve mass surveillance. So instead of just targeting one device, you're targeting one server or one fiber optic cable, and through which hacking to a large swath of communications. But in the lawful hacking category, you also have individualized or targeted forms of surveillance that can collect a large swath of information about one individual. What I am getting at is that that debate is not matured enough, hardly as in terms of case law, in terms of settled standardization, hardly as settled as this, or as matured as the mass surveillance discourse and case law. And so they're uneven in terms of the regulatory environment. And yet the principles, the core principles that guide that discussion, which again, could they have landed in a better place? Maybe. But those principles could be equally applied here. And that's what I was suggesting in my presentation when I was talking about legality, necessity, proportionality, adequate safeguards. There are a set of basic principles that should guide our spyware discourse as they should guide our surveillance more broadly discourse and our mass surveillance discourse. And we just need to debate where do we land in particular use cases. So if we talk spyware, what does it mean to use a spyware against a device? Should we authorize the live collection or just passive historical data collection? Those are very different invasions upon privacy. And we can apply necessity and proportionality as two emanating frameworks to say maybe we are tolerating data collection, historical data collection, but not authorizing the manipulation of the camera to turn on and collect real live information. That maybe is a step too far. That is taking the existing principle in surveillance law and just applying it to a new technological domain. And so I do think that there's plenty to learn. I do think we use the terms responsible behavior or whatever because we don't want to impose that legalistic framework that mass surveillance has now adopted. Uh, but that's what the politicians are doing slowly. For us as academics writing in this space, I do think the principles should apply equally.
Yeah. Thank you, Asaf. Moving on to the next question that I had, which was, you very nicely laid out what a multi-stakeholder framework would look like, and you've also given us insights into what's been happening with the Montreux document that set up the ICOCA. So I was curious, what are the chances
Oh.
of, a multilateral framework happening in the cyber intrusion space? you know, what are the chances that you give it? How realistic is it? Um, with that, what do you see as the biggest challenges? Sort of what are the biggest challenges? What are the biggest drivers towards that? And if that is a goal that is, further off in the future, what would you suggest different stakeholders in this community can do in the meantime to, drive this debate forward to get to that point eventually?
Yeah. So when I wrote Selling Surveillance, I was far more optimistic than I am today, in part because during the period of 2023, 2024, there seemed to have been a momentum for precisely this kind of a international framework that was pushed equally by two set of actors at once. On the one hand, the United States through those efforts in the Summit for Democracy, many of it pushed domestically by efforts from Congress to enforce against particular bad actors in the spyware space because some of the spyware technologies was being used against US American officials in a way that threatened American interests. And so that pushed America to be a leader in this space. And it brought together, indeed, as I was mentioning, 45 countries to come together and agree on a first step of these guiding principles, which of course had no legal meaning as such. And simultaneously, there was this Pall Mall process that happened across the pond, pushed by the French and the UK foreign ministries, that tried to bring together a large swath of governments, predominantly from the global north, predominantly, though, the powerful, most procuring countries who have the wallets to thereby leverage their power to set a set of principles, responsible principles for the use of spyware tools of this kind. Um, and so this pincer movement, I thought, might have a shot at getting us closer to a framework. Fast forward to 2025, we are currently in a different space where there is lack of motivation, at least on the United States side, to actually advance these sorts of multilateral efforts. I think that, if anything, what we've seen from the Trump administration's are effort to restrict internationalizations of problems and to develop new multilateral solutions and institutions to the regulations of these sorts of problems. The Pall Mall process continues on, predominantly through consultative processes that involve the tech companies in a multi-stakeholder sort of way, precisely of the kind that I'm imagining, but still very kind of step by step, not developing anything with teeth of the kind that I'm imagining myself. And so and I think fearful and mindful of the fact that there are a lot of political turmoil at the moment and that lack of political motivation would be a hindrance towards this kind of multilateral solution. And so, in the interim, I do think that what we need is leadership. We need a set of actors with the energy, motivation, and guts to come out at the international plane and say, we will only buy these sorts of tools from only those companies that agree to play ball under our rules, and then actually utilizing their procurement power to create this kind of club as a first step. And over time, the club could develop its structures and infrastructures and rules and guidelines and enforcement and accountability and all of that. But we need to start somewhere. A country that has the confidence to say, recognizing that this might risk me, that companies might leave my shores because they don't want to be beholden to my higher standards. But I'm willing to tolerate the risk of losing some cyber power in my own territory in the name of potentially setting up a movement. And again, I don't know if we're at a time where there's enough countries willing to take bold action. But there's certainly countries who and this problem is not unique to the Spyware debate. It's true to all human rights debates, IHL, in the wake of wars in the world. This is a hard time for multilateralism. And so we are constantly calling for other countries to pick up a mantle that the United States has dropped in this particular difficult year that we've been in.
So let me pick up right there. I really appreciated your characterization. It's a tough time for multilateralism all around. It's not just specific to spyware. It's not just specific to the cybersecurity field. It pervades any and every issue area in international law and or international relations. So with that in mind, I want to circle back to how you started your presentation. With the chasm and the sort of, I'll call them very dogmatic positions on both sides of, that cliff there. So I'm curious, you characterized yourself as a pragmatist. So moving forward in, this challenging multilateral environment or non-multilateral environment, geopolitical environment, how do we empower the pragmatists? How
Mhm.
do we give more weight or more voice to those ones in the middle that, without glorification, but, that tend to see both sides, both needs or all the equities that are at stake in this that undoubtedly will have to be balanced in one way or another. How do we empower those in the middle to have their voices heard more clearly?
That's a research agenda for the ages, that question. So listen, part of the challenge of operating in the middle is that you are constantly criticized from both sides for not adopting the purist stance. And I think that it is very difficult to develop complex answers to complex problems when it's so much simpler to give a dogmatic, simple answer to problems. Just ban it. Or on the other hand, just use it. International law is useless, so it doesn't work. Like those are extremes that I don't think reflects the complexity of the problems involved. I think empowerment starts from modeling behavior. So it starts from demonstrating that solutions are achievable, and that the only kind of solutions can only come from compromises. We again, I don't. We can think about all sorts of political crises. I'll just mention the one we just came out of, which is the longest governmental shutdown in American history, right? Listen, you can debate whether or not the Democrats made the savviest political move in ending the shutdown, as an example. But the solution was a compromise whereby by the pushing negotiations until January. Doesn't matter the political context. It demonstrates those Democrats are being thrown around and ridiculed by their colleagues for doing that brave thing that ended the shutdown. And there's disagreement whether or not that was the right move, but certainly for the people who are hurting, it ended something that really suffered, that really made them suffer. And I'm really concerned about those kinds of risks. I'm concerned about the victims of spyware, and I'm concerned about the need to investigate seriously crime and terrorism. And both of those things are equally important in my mind and equally deserving of our response. And so, in that light, I don't think that there is any other solution but something that is in the middle. And until I'm proven otherwise, that is the kind of advocacy that I will be engaged in. Yeah.
Thank you, Asif. That was a very nice closing statement,
Yeah.
wrapping up our hour-long discussion. With that, we are unfortunately at the end of the hour. I would like to thank Dr. Asaf Lubin for taking the time and sharing his perspective with us. Well, I hope everyone, well, I can say I enjoyed it immensely. I hope everybody else did. You can find a recording on this online for anybody who would like to rewatch it or recommend it to others. And with that, thanks very much, Asif.
Thank you so much for having me. It's been great.